26 years ago, I did my first jury trial. I'll never forget it. The most terrifying thing I had done up to that point. It was a Title VII employment discrimination case. And we had to select a jury because I had an attorney to accompany me at that time. Our goal, of course, was to get an impartial jury, a jury that represented a cross section of the community. And that's what we're going to talk about today, selecting a jury. And did you not know that when the attorneys or the judge select the jury in violation of due process, the defendant or the person who the jury selection affects can file or challenge a Batson motion? And what the Batson motion does is question the attorneys or the judges striking certain jurors based on the juror's race, based on the juror's sex. But today's discussion is going to concern discrimination based on the person's race and how that petitioner can challenge the jury by executing a Batson motion. So let's get started. Voir dire, it involves the judge and attorneys questioning potential jurors to identify bias. If the judge or the attorney deems the potential juror to be biased, then he or she can move to strike the potential juror from the pool for cause or through a peremptory challenge. For cause strikes are based on clear evidence of bias or inability to serve, whereas peremptory strikes are a limited number of challenges that the attorney gets without needing to explain the reason for striking the individual. Pro se, or any person affected by the strike, be vigilant and ready to file the Batson motion if necessary, because attorneys often use this strike just because they think they can, and they don't expect the pro se or the person affected by the strike to challenge them, especially prosecutors when the state is prosecuting the defendant who is often a pro se. Be vigilant. And I want to introduce to some two terms that are important to this discussion. The veneer. A veneer or jury pool or jury panel is a group of prospective jurors from which a petit jury is ultimately selected. The petit jury is the specific group of jurors who actually hear and decide a case. So, to help us address this subject matter, we're going to look at Batson versus Kentucky, 476 United States Supreme Court, 79, a 1986 case. So let's look at the facts. Batson, a black man, was on trial charged with second-degree burglary and receipt of stolen goods. During the trial, the judge conducted voir dire examination of the jury veneer and excused certain jurors for cause. The prosecutor then used his peremptory challenges to strike all four black persons on the veneer, and a jury composed only of white persons was selected. The defense counsel moved to discharge the jury on the ground that the prosecutor's removal of the black veneerman violated petitioner's rights under the 6th and 14th Amendments to a jury drawn from a cross section of the community and under the 14th Amendment to equal protection of the laws. Without expressly ruling on petitioner's request for a hearing, the trial judge denied the motion and the jury ultimately convicted petitioner. Affirming the conviction, the Kentucky Supreme Court found that the prosecutor's use of the peremptory challenges to exclude Black jurors did not violate Batson's rights. Of course, Batson appealed to the United States Supreme Court through a writ of certiorari. The burden is on the petitioner, in this case, Batson, to show the prosecutor's peremptory challenges to exclude the potential juries was solely based on their race, in this case, violating the Equal Protection Clause of the 14th Amendment. So let's look at the Supreme Court's analysis. The issue for the Supreme Court was, did the prosecutor's use of peremptory challenges to exclude the 4 Blacks from the jury violate Batson's 6th and 14th Amendment rights to a fair jury trial and his 14th Amendment right to equal protection of the laws? This case set forth the rule of law, stating a prosecutor cannot use peremptory challenges to exclude potential jurors solely based on their race, violating Equal Protection Clause of the 14th Amendment. This case established that a defendant can challenge the racial makeup of a jury and that the prosecution must provide a race neutral explanation for striking potential jurors if a discriminatory pattern is shown. So let's look at the prima facie elements. Remember, every cause of action has prima facie elements that must be established, especially to survive a dismissal. The first element is that the petitioner must show that he or she is a member of a cognizable racial group. In this case, the petitioner is Black. 2, the petitioner must establish that the prosecutor has exercised peremptory challenges to remove from the veneer members of the defendant's race. Well, that happened in this case. 3, defendant may also rely on the fact that peremptory challenges constitute a jury selection practice that permits those to discriminate who are of a mind to discriminate. And apparently, Batson met this prong, at least to the extent that he would survive a dismissal, as we will see later on. And 4, finally, the defendant must show that such facts and any other relevant circumstances raise an inference that the prosecutor used peremptory challenges to exclude the veneermen from the petit jury on account of their race. Now, prior to the trial commencing, I would have researched the prosecutor and his or her office practice concerning cause and peremptory strikes. This information could potentially help raise an inference of discrimination, even purposeful discrimination. So let's look at some examples of evidence that would support discrimination. Relying on facts that the peremptory challenge system as a whole was being perverted. For example, obtaining a 10-year record of the prosecutor's office showing that the office engaged in unlawful strikes because of a person's race or their sex. In other words, it shows a perverted system. Two, in the selection of the veneer by relying solely on the facts concerning its selection in the petitioner's case. For example, facts that the prosecutor continues to give inconsistent explanations. Three, rely solely on evidence concerning the prosecutor's exercise of peremptory challenges at the defendant's trial. For example, where the prosecutor uses discriminatory language or comments during the voir dire that suggests discriminatory intent. Once the defendant makes a prima facie showing, the burden shifts to the state to come forward with a neutral explanation for challenging Black jurors in this case. The prosecutor may not rebut a prima facie showing by stating that he or she challenged the jurors on the assumption that the jurors, would be partial to the defendants because of their shared race. So finally, let's look at what the Supreme Court, or how the Supreme Court ruled. In this case, the Supreme Court, petitioner made a timely objection to the prosecutor's removal of all Black persons on the veneer because the trial court flatly rejected the objection without requiring the prosecutor to give an explanation for his action. We remand this case for further proceedings. If the trial court decides that the facts establish prima facie purposeful discrimination and the prosecutor does not come forward with a neutral explanation for his action, our precedents require that petitioner's conviction be reversed. And the following cases are precedents that the Supreme Court wrote. Next, I want to turn you on to the Center for Death Penalty Litigation. They cite two Batson motions that are essential when a petitioner is filing the motion. The first one is entitled Defendant's Motion for Complete Recordation of All Pretrial and Trial Proceedings. The second one is entitled Defendant's Motion to Distribute Juror Questionnaire and to note race and gender of every potential juror examined in this case. They say it's also essential. Now, here is the link. I'm going to leave this link in the description page of the video. Okay? Litigation, yes, it's difficult, but it's doable. Have confidence in the facts, have confidence in the law, be able to establish the prima facie elements, and clearly present your case in your document. You can do this. I am Advocate Lucinda, your empowerment lawyer, and we will see you next time. Take care.